Welcome to the Future Media Podcast. I'm Ricky Sutton.
And I'm Alan Chappell. And this podcast goes deep into the collision of big tech
and the future of the world.
We explore how companies like Google, Meta, and Apple are impacting each of our lives.
I'm an investigative journalist.
I'm a privacy lawyer.
And every week we speak with experts to bring the unreported details into the light.
Hey, so yesterday, in reaction to readers of my newsletter, I posted a note on LinkedIn, and it said, when a court validates a monopolist by allowing it to continue its illegal behavior, three things will inevitably happen. Number one, the monopolist will become richer and more powerful. Number two, the rivals who were denied the chance to compete are all going to sue. And three, billions of customers and consumers are going to suffer. And 1 and 2 have happened this week. Google's passed $3 trillion in valuation, so that proves that the first bit is true. And then Magnite, OpenX, and PubMatic, who are all competitors, have all filed suits, and there are dozens of others sitting in the background. But number 3 is happening too. We're just not feeling it yet. And unchecked, the open web, as we know and love, is doomed. And so I posted on LinkedIn, if you want to resist, now has to be the time to step up. And so it's a really scary, difficult, hard time for all of us. But today, our guest is John Newman, professor at the University of Memphis School of Law, former deputy director at the FTC's Bureau of Competition, and the ex-trial attorney at the DOJ antitrust division. So thank you for joining us. Now, many lawyers have been very cautious in their responses to this. He hasn't. He said some really interesting things, and I'm going to quote some of your work here. I hope you don't mind. You said this remedy order won't undo or even halt the illegal acts. Google can keep paying Apple billions and keep throwing its enormous profits around to preserve monopoly power. Letting Google keep engaging in most of its harmful conduct entails real costs for consumers and society. And the shorthand basically is, there's a lot more of this, we'll talk about it now, but the shorthand basically here is that the antitrust ruling didn't deal with the problems that we really have. It bet the bank on the future and on AI and sacrificed the news industry in the process. I'm not even sure if that was even a consideration. And now, 16 days since the judgment, we have another judgment coming. This all feels very chaotic and very confused. And we're not in Kansas anymore, right? This is all changed. So we've all had a bit of time to stew. John, how are you feeling?
Not great. Not as bad as I could have possibly felt, right? And I do think that's worth keeping in mind before we get into why I'm not feeling too great. And it sounds like you're not feeling too great either. I think it is worth keeping in mind that the judge could have done less, right? There are classic cases throughout antitrust history where judges actually found monopolies had happened, they'd broken the law, and then just declined to do anything, right? That has happened a few times. It is not our finest moment in antitrust law, but that has happened. So there was a world in which Judge Mehta just kind of threw up his hands and said, I'm going to basically do nothing here. He went a little further than that, but not much. And that's why I'm not feeling great. I take it that's why you're not feeling great either.
So I'm confused a little bit by this. So please help me. Apart from the fact I'm raging about the fact that, there was an opportunity here to right some very, very, very clear wrongs. I don't really know how you define a wrong more clearly than the original verdict in this case, all right? It was pretty clear and stated very clearly what the problems were. But the remedy that has been issued here doesn't appear to solve any of those. What it appears to do is say, let's build AI in the future, but it doesn't fix any of the wrongs that were done in the past. And my beloved publishing industry is probably the most wronged in all those places. So it doesn't feel like a remedy. It feels like an accelerant for the future. How am I supposed to feel about that?
Not great. I think you're absolutely justified in feeling frustrated by this. I think if we want to think about this decision at a high level, it's almost as if the judge viewed this as a sort of zero-sum game. Well, if I do a little over here, I've got to, reduce what I do over here. And so I think the judge kind of looked at the facts and said, I'm going to do a little bit on the AI front. Maybe I don't have to do that. I'm going to extend the scope of this to include some generative AI conduct by Google. But that means then I have to make the prohibitions much less severe. That means I can't do much over on this side of things. I can't do this. I can't do that. So it's just a bizarre way of thinking about how to fix a problem, right? You don't look at a problem and say, oh man, if I do a little bit to fix it, that means I have to do less over here to try to fix it as well. It's just absolutely not how judges are supposed to think about this, right? You're confronting a massive problem. And he said that in his own liability decision. He said, this is a decades-long monopoly. Google's illegal conduct, which is something like 6 different flavors of contractual restrictions and provisions, have entrenched its monopoly for over a decade in 2 distinct relevant markets. And they are, by the way, 2 of the most important, I think, markets in the world, right? This is how people interact with information in an information age. It doesn't get more important than that. He seemed to recognize that in his own liability opinion not even a year ago. And then this comes out and he's looking at the world and saying, as you said, I'm going to just kind of gamble on the future fixing the problem for me. I'm not going to do much by way of actual structural separation here or structural relief that would actually reshape this market. And I'm not even going to stop all the illegal conduct. That's the part that really rubs me the wrong way. And I just don't see how you do that.
How is that possible? This is what I get confused by. If I read the original complaint, AI was barely mentioned. If I read the verdict a year ago, it's mentioned a handful of times. In the decision at the end of it, it's mentioned dozens of times. I was asked on stage, I was at a conference in New Orleans at the Online News Association. I was asked about it the other day and I said, it feels a little bit like I stole a loaf of bread 10 years ago. All right. And everybody knows that I stole the loaf of bread and now I'm about to be punished for that. Okay. But when it comes to the court case, I just tell them I'm opening a bakery and therefore everybody's okay. Let's forget about it. There are people that were wronged here that have no remedy whatsoever. Okay. Because we're just going to build American supremacy in AI. Half of the world's journalists are out of a job. Half of the world's publications have disappeared. We were crushed by a monopoly. There was an opportunity here to right a wrong and it wasn't taken. What are we as an industry? Just before I let Alan dive in, because he's got 1 million views as well. But from my perspective, what are we as an industry meant to do in that scenario? Because there was no question that we have suffered and bad things were done to us. But the answer is we're just going to bypass that because we just don't have time because we're looking over here.
Yeah, I mean, it's almost worse than the bakery example, isn't it? It's almost as if you stole a loaf of bread and you're not even saying, I'm going to open a bakery. It's like you're pointing across the street and saying, yeah, I stole the loaf of bread, but look, there's a few thieves over there too. Maybe that excuses my conduct somehow. It boggles the mind, right? I mean, I think everybody thought at a bare minimum, and the law says you have to, at a bare minimum, as a judge, terminate the illegal conduct. I mean, it's table stakes for remedy, right? You see illegal stuff, it's still going on. How do you not stop it? I used to say there's no Robin Hood defense in antitrust, right? You're not really supposed to rob from even the poor and give to the rich, or rob from the rich and give to the poor, whatever. I'm just not sure that's true anymore, right? I think that's kind of what Google got away with. They said, we are going to rob from almost everyone. And in fact, it's sort of robbing from the poor. And we're going to give it to the rich, Apple, right? And a few other companies, but Apple primarily. It's worse than a Robin Hood defense. It's like a reverse Robin Hood. I don't even know what to call it. I think it's really frustrating. So what's to be done? I don't really see a path to getting a really strong, really effective remedy on appeal here. I just think the judge has set the bar so low. It's in such a bad place that even if you somehow got an appellate court to, reverse on some aspects, they'd have to just go so far in the other direction to fix this. I don't really see this case as the vehicle. I think that means if you want to use antitrust as the tool here, it's got to be new cases. It's got to be filed in different courts. You just got to get out of DC. Frankly, I think these judges are too cloistered. They've all got eyes on the Supreme Court, so they're all making narrow little decisions, technicalities, that sort of thing seem to drive the opinions way too much in that particular court. So I'd say, let's get out of DC. Let's try a new case. Let's try a different judge.
So let me offer a counter narrative, and then I'm going to duck because I think Ricky may take a swing at me. I don't know. Isn't at the end of the day, the challenge here is that they're just, unless you're going to go all the way with divestment, everything else is meaningless. Data sharing is just almost quaint because you don't need the same amount of data in the era of AI. Microsoft has already said that. And the distribution agreements, yeah, they should have canceled the distribution agreements. That's a whole other, we can get to that. But unless you're going to do divestment, none of the other stuff really matters. And the problem with that is that there just isn't a good home for the Chrome browser. I know Ricky has been very, very supportive of the idea that a publisher consortium steps up. It might have been helpful, by the way, for a publisher consortium to have stepped up in the same way that Perplexity sort of did, even if, like Perplexity, it was mostly a PR stunt. But leaving that aside, like I don't think there's a great home for Chrome that fits two categories or two criteria. The first is, can they afford it? And then the second is, can we trust them not to use Chrome to ruin the internet further? And Perplexity has already said what they were going to do with it. And I don't know that Microsoft or even Yahoo was going to provide a better home for it. But isn't that really the problem?
And can I just add just a corollary just to that question, please? There's a line in the ruling that said that the people that will get the data, and therefore the people that would have potentially got Chrome, have to pass US national security rules. That doesn't feel like a legal requirement. That feels like a political requirement. So please, can I just throw that on top and just say, like, what does all of that mean? Because it really limits the capacity and the opportunity.
Yeah, potentially. I mean, maybe taking that second one first, if I could. So, yeah, there are laws in the U.S. CFIUS is one that say you've got to undergo a national security review if you do certain acquisitions.
Well, then there's
in the past,
right? PADFA and the DOJ bulk data rules. Sorry to step on.
No, not at all. Yeah, so there are certain laws on the books. In the past, I think I would have said, don't worry about it. These are, really pro forma. I think you're right. In the current climate, it's just really hard to predict which, if any, non-US buyers are going to be able to do deals here. I mean, so far, we haven't seen a ton of activity there, but I think the threat is there. There's a sort of Damocles hanging over any non-US buyer here, which might shrink the universe considerably. That said, I mean, getting back to this question about whether there's a good owner for Chrome out there, to me, first thing to keep in mind is antitrust is not going to be able to solve everything, right? That said, I don't think we should let the perfect be the enemy of the good. So let's say there's a Perplexity out there. They're not going to do right by everybody. They're not going to do right by all stakeholders. They're probably not going to do right by the news industry, among other things. But at some point, antitrust runs out. We say, look, at least they could maybe help to dislodge that Google monopoly. Beyond that, maybe we need more laws on the books. Maybe we need agency rulemakings, right? Let's get these regulators involved and actually hem in and control, set some rules for the road.
You're approximately 1 year too late with that pitch.
Well, I was thinking fondly of my old boss, Lena Khan. There's a world in which maybe that happens. Maybe it doesn't happen for a little while. But, hey, this stuff is all contestable. There will be a new administration at some point. But yeah, I do think antitrust runs out at some point. And finding a perfect buyer that's going to do right by everybody may be that point. That said, again, I don't know if we should let that be the enemy of at least unseating the current monopoly.
So I'm going to be very critical of the judge in a minute, but I do want to at least express a certain level of sympathy for those of us I've been in digital for 25 years. I have I feel like I have a PhD in shenanigans from Google over the years. I've reached the point where I would prefer that they just blow the whole darn thing up into smithereens and we just hope for the best. But I can kind of see a judge who isn't as well versed in this maybe being a little more reluctant to do that. Any sympathy to that argument?
Yeah, I mean, if you look at the judge's opinion, it does read at times like a sort of tortured, on the one hand, on the other hand, there's a part of the opinion that I'm actually very sympathetic to, where he says, look, I'm not a prognosticator of the future. If I were, I'd be on Wall Street, right? I'd be making bets on what's going to happen. Just not my job as a judge to be able to predict the future.
Okay,
where I run out of sympathy,
but then turn down the case. Maybe you turn down the once in a lifetime 100%. Case.
Right. Where I run out of sympathy is where you then go on to actually gamble on our future, right? Make a really high stakes bet on a very uncertain.
That's it. Future. He did gamble. That's the thing, right? And it's sort of like, this was not judicial restraint.
Yeah, I mean, I think if we want to get a little bit meta, haha, for just a second here, this is a judge who I think is sort of unaware that they're swimming through a sort of neoliberal pool, right? They're kind of looking around and saying, I'm not sure I'm wet. Well, yeah, you actually are. It's in a very deep pool of sort of neoliberal ways of viewing the world, right? And if you have that worldview, even if you're unconscious of it, you think the risky thing to do is to issue a strong judgment, right? Oh, that's government intervention into the marketplace. You guys are looking at this, and to some extent, I'm looking at this and saying, actually, I think the risky thing to do is to issue the narrow judgment here. But this opinion reads like a judge who's actually not even aware that what they're doing it really is proceeding on a bunch of assumptions that I'm not sure line up with reality.
So I've just come back from an international tour talking about this specific topic. Okay, this was the only question. I've got two questions for you. The first one is that there are 36,000 publishers of note around the world, which is going to be 10 inside a decade if we don't make some changes to sustain the ecosystem within which these people operate. Okay, and I don't think that's good for anybody. And the open web, about 30% of the content of the open web, about 300 billion page views of content of the open web comes from those professional publishers. So the actual conversation the world is having, it's undisclosed and unconsidered and unappreciated how much of it is provided by these publishers. But they have every attempt they make to try and do the right thing, to be given an opportunity to maintain their voice or survive, gets crushed. And, they've tried to work with the tech companies, and that's worked against them. They've tried to work with government, and that's failed. They've tried to work with the law, and now that's failed. They're rapidly running out of anywhere to go. So if you were representing all of those publishers, my first question is what would you recommend they do? The second thing I'd say is, on the plane, I watched Blade Runner again, okay? And I'm just watching the Tyrell Corporation. I'm just going, that feels bad. That feels like we're headed. There's going to be one corporation that runs everything, because it just feels that we've just entrenched them with this ruling. So my two questions are, number one, a third of the web wants your help. Please tell us what to do. And number two, how do we just not feel, damn it, I'm just going to have to go into subsistence farming in the mountains because this career in journalism is over?
I'm tempted to ask whether it was the original Blade Runner.
I was the original.
Ryan.
The first one.
Okay, good.
Yeah.
Good. The correct one. Okay. What do we do? I think it's right that the current toolkit that's familiar to people seems to have kind of run out of steam when it comes to this sort of problem. So what do? Either I think you give up, or you start doing some kind of boots on the ground organizing in the real world, not in the courtroom. Or option three, and as a law professor and former practitioner, you may anticipate this is my favorite option. You get creative, right? And we've seen that, right? There's a recent lawsuit that was filed. Somebody looked at the facts of this case, looked at DOJ's request for a remedy, looked at what happened and said, there's still room for action here. There's still room for antitrust to operate. In particular, this fact jumped out to me from the opinions where, the judge admits, yeah, Google is going out saying to publishers, let us take everything you own. And if you don't do it, I'm going to blacklist you from the search results pages. And you're going to disappear from the face of the internet, essentially. That's the kind of thing you just talk about to a normal person and say, that can't be allowed. That can't be legal. Man, but when you look at it from our sort of familiar antitrust toolkit, I don't know what to do about this. It kind of feels like that's what the judge said. He said, I'm not going to do anything about that. All right, let's get creative. When's the last time we had as sprawling of conglomerates as Google? You in the US, you have to go back to the 1960s and 70s, to the true heyday of the old conglomerate business model. After the 80s hit, corporate raiders started dismantling these companies, and you didn't really see those real old conglomerates. They operate in hundreds of different markets. Google's like that, though, right? There are laws on the books, there's cases on the books that recognize things like reciprocal dealing. This is a weird old antitrust theory that I haven't seen used for 5 decades. But it's basically, instead of me saying to you, I'll sell you product A, but you have to take product B, it's saying to you, you've got to give me product A, and in exchange, I'll give you my product B. It's a weird fact pattern. It only happens if you make so many different products that you're simultaneously providing to and taking from the same people, right? That's what Google does with publishers. There are case theories on the books that can deal with that sort of thing. we just haven't used them for so long because we haven't seen a company like Google for so long. Then who knows? We got some dusty old bombs down in the basement. Maybe hauling them out could create that explosion of competition you guys were talking about a second
Oh, so you're telling me I got to become a class action litigant?
ago.
I don't know, man.
That's not the end of the world. Not the worst thing.
So there's a note actually in his ruling, in Judge Mehta's ruling. I love the fact we've now got 3 Metas, by the way. We've got we're talking about the Meta business position. We got Meta himself, and we've got Meta the company. Kind of amazing. But there was a note in his ruling that basically said, I'm not doing anything about the publishers and the suffering of the publishers here, even though it's very clearly proven that they've suffered. But I didn't hear any evidence from anybody. Now, after that, I didn't hear any evidence from any publishers. After I read that, I rang the DOJ and spoke to the DOJ about it. And they said, well, we had to decide where we were going to put our evidence. And so we actually put the publisher's evidence in the ad tech antitrust trial, which is coming up. But it sounded to me, that sounded like a call to action from the judge. It almost sounded as if it was, please bring a suit on this because I actually have sympathy for this. Did you read it as that?
Potentially. This is a judge who does, kind of play their cards fairly close to their chest, I think. Every line in the opinion is very carefully crafted to present a certain image, I think. So it's a little hard to know exactly what to do with that. That said, yeah, I think he was not at all dismissive or resistant to the idea. I think, as you said, he framed it a very particular way. I don't have the evidence to base this on. So yeah, it looking back maybe feels like a bit of a missed opportunity that those 2 cases were brought so separately, right? Separate lawsuits, separate court systems. When you read the ad tech complaint and then you read the Google complaint, the old one, 2020, right? There's a world in which those narratives fit together, right? Because Google did start with the search monopoly and expanded outward into the ad tech monopoly. Those things were not unconnected. So there is a world in which this gets brought as a real big, old style antitrust case in the Standard Oil tradition, or maybe even the Microsoft tradition, and you actually get some more meaningful remedies. That's not how we ended up, though. We ended up with this piecemeal approach. It's a little bit unfortunate.
Would it be okay with you if I published your email address in my newsletter and invited 36,000 publishers to tell you exactly how they're feeling right now?
Oof. I'm feeling like what's the goat who takes the punishment for the city? I'm feeling that way.
I was just sort of curious. There's a whole bunch in there about not upsetting the apple cart. And part of that was, if we stop allowing Google to bribe Mozilla and Apple, that's going to create downstream problems. And I'm really struck by that because it's like, all right, firstly, I have some sympathy for Mozilla. I think some of this is their own fault, but fair enough. They've lost a ton of market share over the last decade, mostly due to Google. But it isn't helpful to the marketplace if we have other browsers out there who are solely reliant on the revenue from Google. Like, that's not a good outcome either. That's certainly not a competitive outcome. And it's weird I don't think you have to be a genius in how the internet works to see that. I apologize, John. This is starting to gravitate quickly into a therapy session, but walk me off the ledge here.
Yeah, no, it is really frustrating. First off, as your therapist, let me say that's absolutely a valid way to feel. It is very frustrating. How was that? Was that pretty good?
That was great.
Okay, so super frustrating to see a judge look at the world and feel this way. Like, oh, well, I guess this is just the world Google has made. We must all live in it and nobody can do anything about it. You're the judge. You're the one person who can do something about this. It's a little bit reminiscent of when we were trying to bring the first US-based challenges to any acquisitions by big tech companies. The first one over here was Meta Within. UK had gotten out in front of us on Meta Giphy, but ours was Meta Within. And one of the huge counter narratives we experienced was, well, oh my God, if we block any of these big tech acquisitions, all of a sudden Silicon Valley's entire funding model is going to collapse because every startup does what they do in order to get bought out by Google. And to me, that never resonated. That's so frustrating. It's like, that's just not how we should be doing this. Yeah, it is how we're doing it, but only because we've let an entrenched monopoly live for so long, so comfortably. So yeah, there is something like that going on with this opinion. To my mind, the way you deal with that then is not to just say, oh, I guess we're just stuck living in Google's world forever. You get creative. You're a judge. You're doing equity. You're supposed to be doing fairness. You're supposed to be doing right. I'm a little sympathetic to Mozilla as well. Well, okay, let's just craft a remedy that says you can continue making payments to nonprofit organizations since they don't have obvious alternative funding streams. Great. Now we stop the payments to Apple, who doesn't really need the money anyway. We keep some sort of lifeline afloat from the Mozillas of the world, and at least you've done something, right?
Yeah. And then to your earlier comments about, did they maybe miss the moment by not combining these two cases back then? You may have a better perspective than I, but my understanding is that the government had to come at Microsoft, 3 times before they hit the sweet spot. And I just wonder if that's sort of happening here. It's really hard to do this. And by the way, even in the ad tech case, I would argue that they made a mistake by focusing way too much on the sell side, on the publisher side of the equation, and not nearly enough on the buy side. And without focusing on both, you've kind of set yourself up to a set of remedies that I really don't think are likely to be effective either.
Yeah, and I think it's a great point. And I will throw in the mix as a former regulator, the resource concerns are real. The bigger a case gets, almost exponentially more resources it takes. One of these cases alone puts a big strain on an agency to try to do that case as even bigger, right? An all-encompassing US v. Google. It could have broken the agency. So there's some very real concerns there. 2, I think there may be some upside, right? You've now got 3 cases if you count Epic v. Google. You've got 3 cases where judges have laid down markers and said, here's a valid, relevant market. Here's monopolization of that market, right? I used to say when I was in practice, just defining the relevant market and proving somebody has power in that market, that's at least half the battle. And now that's already been fought on, by my count, 6 different fronts. So if publishers want to bring cases on any of those battlegrounds, the government has paved a lot of the way for them. I think that is a silver lining to all of this.
I think that's a fair point. And that sort of gets us to, do we think the various parties are going to appeal? I mean, the DOJ, bless their hearts, were practically declaring victory in some of their early press releases. So I'm hopeful that they're going to appeal, but I'm not sure that's a certainty at this point. Seems like Google's going to want to appeal because I think, to your earlier point, they want to get the liability of being adjudicated monopolist off of their books, if possible. That may be too heavy a lift, but I do think that at this point they're likely to go for that. Do you agree? Disagree?
This is a surprisingly tough one to predict. I mean, usually I would say 99% chance the defendant's going to appeal any unfavorable decision on liability. Because if for no other reason, then you get to drag it out for a couple more years. You get to keep your monopoly profits rolling in. It's wonderful. The monopolist wins. Everybody else loses. This one's tough. Let's start with the government perspective. That's one I'm more familiar with. The chances, to my mind, of actually getting a really substantially more favorable decision on appeal are not high, candidly. The DC Circuit is a tough place to be. I don't know if you all took a look at that New York v. Facebook. Right, so the Facebook complaint, there was the government one, and then there was the state one. New York v. Facebook went up on appeal to the D.C. Circuit. They got a horrific opinion by a judge named Judge Randolph. So if you're DOJ, you're looking at the appellate panels you might draw and starting to wonder if you might actually get a much worse opinion even than what you got. And as he said, they were taking a bit of a victory lap because they got, something here. So it's not obvious to me that DOJ appeals it. Google, I would ordinarily say, yeah, they're going to appeal, at least on the liability holdings. And maybe that's how they do it. Maybe they just appeal on liability. The thing that counsels against that is Google stock, as you guys said, it is gone, skyrocketed. I think Wall Street's looking at this and saying, this was a huge win for Google. You're Google CEO. You're nominally responsible to your shareholders. They might be wondering why you're trying to get a potentially different outcome when this one was apparently so good for your own bottom line. So, man, it's almost a coin flip to me at this point, whether this one just ends up sitting the way it stands.
What's going to happen on that is that if the guilty verdicts stand and it's not appealed, there's going to be a global class action brought by publishers on the basis of the ruling. Okay, and so I'm involved in about $15 billion of class actions in Canada, Europe, and here in Asia. And so Google will get a $15 billion class action, which is very difficult to defend with that sitting on the books. But that's just the price of business. They've shown again and again and again that they consider that just to be the cost of business, right? And so they can walk away from that. What I do, I come back to the Tyrell Corporation, though, to be honest with you. The problem here is that, these corporations have now shown that they're so large, so powerful. They weren't dealt with when they were manageable 10, 15 years ago when you were at the FTC and the DOJ. And so any remedy looks really incredibly draconian and complicated and breaks the entire open web because we didn't deal with the cancer earlier, right? And so now what do you do? I mean, do you just like throw your hands up and just go, it's too hard? Because I kind of put myself, I'm sympathetic as well to Judge Mehta in a way, because I reckon at 4:28 in the morning one day in the last 6 months, he's woken up and just gone, oh, hang on a minute. I think the entire future of the economy of the world rests on my decision here. Yeah? What do you do? I mean, how do you deal with that? And I know you're a judge and that's your job, okay? But you have to have a bit of sympathy for that responsibility sits on my shoulders alone.
It's a lonely job, right? You are, especially as a district court judge, you are asked to make these decisions by yourself. And sure, of course, you can have conversations with your colleagues, and I'm sure that happens. And maybe somebody says, sure, you're doing the right thing. But at the end of the day, unlike even an appellate judge where you at least get to sit there with two other people and pull the trigger on the firing line, you're being asked to do it by yourself. I think that is it's got to be a humbling task. And of course, as you said, you signed up for the task. So for us, I think it's hard to feel too bad for you. But yeah, I can feel some sympathy. I think that's right. But yeah, at the end of the day here, I think you're right. We're going to see some class actions. You're Google. What are the chances I'm going to have to pay out? Probably pretty high. I'm going to have to pay something. Is it going to be on the order of 10, 20 billion, something I might actually notice? Maybe. Even if it is, it's going to be 5, 6 years from now after we do class certification and motions practice and another trial on damages. And then we go through an appeal process almost certainly on that one. So man, you're Google, you're doing the numbers. What's the net present value even of a $20 billion judgment 6 years from now? It's pennies.
100%. So I want to ask you a question because you're now in academia. You're now training the next generation of lawyers. So what ages are the people that you're teaching, roughly?
They range, but usually they are kind of clustered in one poll around about 22, 23 students who more or less went straight through from university. And then probably another poll right around 27, 28. So you've been out in the world a little bit, long enough to figure out you want to get that law degree.
What I found fascinating about that caucus, that age, is that these are people born into the digital era. They've never known a world without Google. For many of them, I would imagine that they think Google is search and there isn't anything else. And Google is advertising and there isn't anything else. And Meta is social and there isn't anything else. So from their perspective of the world, they have a very different perspective than perhaps some of us have been around a little bit longer. How do you help them create laws that matter to reset the agenda if they've never known another agenda? That must be a tricky job.
Such a great question. It is. I think that's exactly right. This set of students, especially the ones who cluster around 21 or 22 years of age, they're more or less the first students who were never even alive at a time when Google wasn't already the world's leading search engine, right? I used to mark, okay, this is the first class that probably doesn't remember a time before Google was the leading search engine. Now they weren't even alive. That being said, I am consistently, pleasantly surprised by how acutely aware this new generation is of the problems with the current web model, right? I mean, they have words for like brain rot, right? They have words that we never even dreamt up, because to us, I think, especially back in 2000, let's say 2010, that period, the internet just seemed to be this new exciting thing. Everything was open, right? It was just a very different world. I think a lot of us at least had some optimistic, hey, the internet's great, it's going to bring down the walls era. They've never had that, right? Getting back to that earlier point, they've never known a world where there weren't a handful of dominant firms controlling most of the gateways and portals to information. So I'm hopeful that they actually are acutely aware of these problems in a deep-seated, like fundamental way that some people of my generation, right, the millennials, really aren't. So how do you get them excited? You can't do it by pointing to Congress and say like, hey, we can lobby Congress and get some new laws on the books. No way. So here's my two go-tos. One, state level. In the US, States is where it's at, right? Right now, California, for instance, is in the process of potentially strengthening their antitrust laws. Among other things, they're thinking about creating their own anti-merger law, right? That would be huge. California is a hotbed for a lot of the mergers and acquisitions that lead to these kinds of problems. They don't have their own merger law right now. If they did, and if it was even stronger than the federal law, that might go some distance toward at least preventing the next wave of monopolists from getting entrenched. The other thing is to say, antitrust is relatively young, right? I also teach classes like contracts. Come on, we trace our contract law all the way back to, feudal England. It's not changing a whole lot. It's pretty well baked in at this point. Antitrust law is a youngin'. It's a baby, relatively speaking. So there's a lot of nooks and crannies. There's a lot of dusty old bombs down in the basement. For instance, the main anti-merger law in the U.S. is the Federal Clayton Act, which prohibits mergers that may substantially lessen competition. The EU, UK have similar laws, use that same language. Ours is unique, though. It goes on to say that mergers are also illegal where they may tend to create a monopoly. Not even where they create a monopoly, but where they may even move us in that direction. That was meant to be a super, super powerful prohibition. We honestly just kind of forgot about it. I've asked enough people, hey, what does this do? Do you know of any cases? They just don't know. We forgot it. It even existed. So I've been working with a few people to kind of dust off that old dusty bomb and see if we might be able to use that, go after some of these deals that even if they aren't substantially lessening competition, maybe because there's no competition at this point, they're still contributing to monopoly power. I think there's a lot of areas of antitrust law like that. They're just ripe for us to pick up and revive.
Please go and find a silk rag and immediately get underway on dusting those things off, because I'm deeply concerned for my industry as to where we land. Alan, last question, because I'm going to have to wrap up.
Well, I was just going to make an observation, and so you can, we can end on this, or you can ask a question. But it's interesting because like a lot of the dusting off stuff that you're talking about echoes some of the conversations I've been having with Samuel Levine and some of the other folks on the privacy front, because you can make the same case that in the Reagan era, somewhere we've forgotten about the privacy laws, and we've seemed to focus on Section 230 as the be-all, end-all. I think we're waiting for that big shift to take place, although I've been waiting for something 50-some-odd years and hasn't quite happened yet, but any day now. So I was supposed to ask a question. Now, here it is. Do you think that there's any appetite at the congressional level to revisit the concept of antitrust? And does this decision maybe spur, the Klobuchars of the world into doubling down there?
I think it's possible. I mean, candidly, right now during this administration, I think it's unlikely, but it is at least possible. I mean, I've been getting some outreach from people on the Hill who are saying, what happened here? Frankly, what the hell happened here? We thought we kind of had this thing under control, right? We put people in place who were going to bring big cases. They brought big cases. We kind of thought we'd fix this problem, and what's going on here. So if anything we're going to do it would be outcomes like this. Candidly, I'm not sure there's a high probability of change, but if we can end on this as a hopeful note, we've been through this before as a country, right? We passed the Sherman Act back in 1890. We brought some big cases. They didn't get the remedies that we thought we wanted. So what did we do? Congress went back to the drawing board. They did at least 3 new statutes in 1914. They massively ramped up antitrust enforcement. And then during that progressive era, we had some real results. We had a different looking political economy. So, I hate to say it because this is my field, it's my love, but maybe antitrust is a bit of a stepping stone on the way to something that actually does, work for us.
So you're saying there's a chance.
That's right. Always a chance.
We are eternal optimists here, so we shall keep on fighting the good fight. And thank you very much indeed for your work. Oh, by the way, I just need your email address for those 36,000 publishers. I'll fix that up for you.
I'll send that.
Amazing. Thank you so much for joining us today. Thank you for your thinking. Thank you for your thoughts. And good to see you, Alan. And we'll see you next time.
Thanks for tuning in. The Future Media Podcast is a production of Future Media and Ricky Sutton.